Well, welcome everyone. Good to see you here and not out there. Although if we finish quickly, go out there. It's really nice. I'm Anthony Paunita. Until January, I was the editor of Corporate Counsel magazine and on the staff of The American Lawyer. Before that, I was an editor at the National Law Journal. Legal journalism is well established in the United States, quite a bit less well established here, and I mean, Britain, it's done pretty well. There's Legal Week that is now a pretty decent website. In Italy, there's actually a constellation of legal sites around one company. It's all legalcommunity.it. And they're trying to do a pretty decent job. A lot of it is gossip, you know, this person came here. But, you know, they're trying to develop a following, and they also have a corporate legal branch, and they're branching into the food business as well, the economics of the food business in Italy, which I think is pretty interesting, and it's a big compartment of what this country does. Next to me is Fabio Bertoni. Years ago, he was my in-house counsel. He very patiently vetted stories that we ran, especially we had one writer who had this thing about getting a hold of copies of emails and constructing long narratives of company officials, especially lawyers who did really bad things. And Fabio very patiently read them line by line and wasn't too bad about telling me to soften stuff or take things out. And now he has probably the best legal job in New York. He's the general counsel of the New Yorker magazine, and he gets to read everything and be in what is still, for journalism these days, a pretty rarefied atmosphere. And to Fabio's left is Richard Sambrook. He's a J-School professor at the Center for Journalism at Cardiff University. He was for 30 years, yeah, we're around the same age, for 30 years at the BBC. And so what we're going to talk about is, I went a little over the top and said the right to disappear. It's really the right to be forgotten, but I thought I would hype it a little. I'll start with some scary stuff, and these two guys are going to try to walk us off the ledge a bit. Right?
See how we go.
So this all started in 2014. There was a man named Mario Costeja Gonzalez who was disturbed that there were a bunch of legal notices that mentioned him, and he said that they weren't relevant anymore, and he complained to, he just wanted links to these removed. And in 2014, a decision by the Court of Justice of the EU held that Google and other search engines, if someone makes a valid request, must remove the links. There are various exceptions to that. One of them is the public's right to know, which should mean that stories, really important stories, or any story that's out there, is basically exempt from being disappeared. I can identify with this a little because a few years ago on our website, we mentioned in passing a couple of Nissan executives, and someone who was a Nissan employee in the United States, but I take it she was fired, decided that my website was the proper forum for us to write an expose about all the bad things that Nissan did about her. to her. And she started a blog that used my name as the URL. And, you know, it went on for months. She took my profile picture from Twitter. She kept writing diatribes like, Anthony, don't you see what Nissan has done? Or Anthony, don't you see that Nissan executives are, you know, doing God only knows what. It just went on for a while. And if you Googled my name about 3 years ago, her blog was at the top. And, you know, personally, I would have loved to have been forgotten at that point. But at the same time, you know, I talked to my lawyers about it, and they said, look, she's a nuisance. Most people will see that she's nuts. It'll go away. And it took about a year, and her blog went down in my rankings. But there's an outlier. There's a case in Italy that involved a restaurateur and a restaurant in Abruzzo. And what happened was there was a crime. It's a little vague, but there was a crime happened in the restaurant. And a small site in the Abruzzo, primadanoi.it, or .it, ran a story about it. And the restaurateur he objected after a while to it being there because he said it was damaging his business, it wasn't really him, it was a crime that appeared there. He complained, and an Italian agency agreed with the site, but the restaurateur was not satisfied with that, sued, and it went all the way up through from trial level to the Supreme Court, the Cassazione here. And basically they ignored the exemption, the public's right to know, and they said, you know, after a while, and by the time it had gotten to the High Court, it was 2.5 years, and they said basically, like yogurt that's left on the shelf, there's an expiration date, the public's right to know has already been satisfied, sort of. They paid lip service to that, and the website pulled the article. That's not a great thing, obviously. We're not sure exactly what kind of precedential value it has because it's a civil system here, so it's not like a common law jurisdiction like in the UK and the US where a high court decision has to be followed with similar cases on down the line. But still, it's worrying. It's not a good thing for Italian journalists and websites, especially smaller ones that don't have the resources to fight back. There was a judgment levied against the site, and the editor's car was impounded. So it affected them very personally. It wasn't as though, you know, David Remnick of The New Yorker told Fabio to deal with it and, you know, continued to do his job. And The New Yorker website was totally unaffected by it. So that's the scary part. So Fabio and Richard are going to talk about what websites, what journalists can do to mitigate these sort of things and protect themselves.
Well, actually, you know, I would, approaching this from a U.S. legal perspective, it really is a very foreign concept, this right to be forgotten to us. When U.S. lawyers first heard about the right to be forgotten, it seemed extremely strange. In the U.S., we, as you all know, the First Amendment protects the right to publish truthful information. So as long as something is truthful, there are very limited circumstances under which a state can require or penalize that speech. So putting aside privacy issues for a second, there is no right to be forgotten, right? So stories like that about the Italian restaurant where a crime happened, it just seems very strange to us that news would have some expiration date. There is no expiration date for news. When I was an American lawyer, we would publish, the legal newspapers would publish court calendars and things like that, which would also often have the names of people who were, under arrest or charged with crimes and were awaiting hearing. And every so often, we would get a request from somebody to say, look, that, I was ultimately acquitted. When people Google my name, this shows up and it's affecting my life. And while we're sympathetic to that for an individual who has this information out there, for us, the bigger picture is the priority on the right to speech, right? And that outweighs the individual right to privacy in that case, right? There's a court case involving the New Yorker from 1946, I think, that says that very clearly, that the individual right of privacy, and to the extent that it's there, is outweighed by the First Amendment right to publish truthful information. This is the tension for us, and American courts traditionally have been very clear that it's resolved in favor of the press, especially again when we're dealing with things like court calendars or things like that. That's part of the historical record, right? These people are arrested on this date. The idea that they could eliminate all trace of their arrests would be troubling, right? So I think there's a case pending now in the UK, a little fuzzy on the details, but a doctor who's committed malpractice a number of times, and say that was several years ago, if he wants to delete the reports on that under the right to be forgotten, he could conceivably do that, and then the public is deprived of the information that this doctor has been accused multiple times of malpractice. So you can easily imagine a lot of situations where the value of the information is really critical. And it's often the case that the value of the information may not be apparent until years later. So, conceivably, maybe, not to get too fantastical, but there might be a real estate developer who has a lot of problems, goes bankrupt a few times, has multiple court cases against him, and eventually becomes president of the United States, just to give an example. It could happen, maybe.
Surely not.
So, if he had been able to eliminate all trace of his bankruptcies or other court cases against him, the times he's been sued by workers at his various real estate developments, we didn't know until really recently that this guy could potentially become president. If he had thought to have these information removed years before, it really limits our ability to report accurately or to understand who he is or his background.
In fact, in 1988, I edited a story in the National Law Journal that went on about his problematic, this certain real estate developers' problematic relationship with lawyers and courts. And at the time, he got wind of it as the reporter started making some inquiries. And after a couple of weeks, he was calling our publisher about every 2 hours demanding that it be pulled. And I spent the better part of a day with a libel lawyer. And then we reran it last year during the presidential campaign. And when we tweeted it, we made sure we tweeted it at the real Donald Trump to see if we got any reaction. This time he was smart enough to ignore it.
according to published reports, with the European Union's data protection rights and the right to be forgotten, Google's received 702,000 requests to delist links from 1,941,000, almost 2 million URLs since May 2014. And in 43% of the cases, they delist the links. So that raises the question, if a link is, and that's not removing the page. The Italian court actually ordered the information taken down altogether. Under the Google right to be forgotten regime, they remove the link. So if you search under the individual's name, you get no result. You don't get that result. But you may find that article is still there. So if you search under some other term, crime in restaurant or something like that, you may get that result. But you have to know what you're looking for, and if you're trying to do research about the individual, you can't find that individual. So 2 million pages affected, 43% of the time Google grants it, and there's a procedure now for if people disagree with Google's decision about whether to delist it or not, then you can file litigation. So that's the concern from a U.S. perspective. That sort of really distorts the public record, and we have no remaining confidence in the historical record, right? There are these gaps that we don't know if there's nothing there really, or if the person has just been really thorough and diligent in having things that they don't want known about them removed. And it's especially troubling in the Italian case, where not only is the link removed, but the actual information is removed. So.
Fabio, thank you very much. Is this one working okay? Yeah, okay. So I'm not a lawyer, and I'm not any kind of expert, I would say, on the right to be forgotten, but I come at this from a kind of general journalistic and now partly academic perspective. And it seems to me this is a classic case of a clash between rights around privacy and rights around freedom of expression, as we've discussed. And in the end, that comes down to definitions and how those competing rights are balanced, and how the interface between the right for privacy and the right for free expression is managed. And we do in Europe, I think people will agree, have a slightly different approach and attitude to it to the US. We don't have the kind of First Amendment rights that the US has, or the primacy of those. And in Europe, well, the UK may soon not be subject to these, but nevertheless, in Europe it's about balancing Article 8 of the EU Convention on Human Rights, about the right to respect for private and family life, which says that everyone has the right to respect for his or her private and family life, their home and their correspondence, and how you balance that against Article 10 of the Convention, which is the right to freedom of expression in accordance with the law. And both of those statements are fine in their own terms, but obviously they come into collision at various times. And in particular, they come into collision at the moment because of the significant changes in context, if you like, brought about by technology in particular. So the quantity of information that's available about people, the speed with which that information is made publicly available, the fact that to all intents and purposes it remains all but permanent in terms of a record available online, its searchability online, so this information is now available to anyone at any time in a way that it wasn't even perhaps 15, 20 years ago. And the fact that we have new intermediaries who are brokering this information and its availability. So all of those are, if you like, recent factors into this, the balance of these competing rights. And I think one of the problems that we have in the examples that we've talked about and some of the other examples is that actually the way that this competition of rights is managed is fairly blunt, and it's not set out in the right to be forgotten particularly well, and therefore a lot of it is left to the discretion of particular judges who may or may not decide how they want to balance those rights. So part of it is a poor definition and a lack of definition from my point of view. part of the lack of definition is what is the public interest and what's in the public interest, and that's something that gets debated and discussed endlessly, certainly within the UK and within journalistic circles, and certainly within legal circles as well, as a defence against certain kinds of journalism. But the implementation of the right to be forgotten, I think, is problematic as well, because it's not well enough defined. And the Free Speech NGO Article 19 in a policy document on this tried to spell out a more precise way of defining how it might be implemented. Let me just quickly run through it. They had 7 criteria for balancing the right to freedom of expression and the right to be forgotten, and they suggested that what needed to be taken into consideration was whether the information in question is of a private nature, whether the applicant had a reasonable expectation of privacy, including the consideration of issues such as prior conduct, consent to publication, or prior existence of the information in the public domain, whether that information at issue is in the public interest, whether the information pertains to a public figure who has perhaps less expectation of a right of privacy than a normal individual, whether the information is part of the public record, including court records and so on, whether the applicant has demonstrated substantial harm, how recent the information is, and whether it retains public interest value, even if it's historical information. Now, that's Article 19's suggestion for trying to put a little bit more meat on the bones of how this should be managed. But at the minute, any of those questions are purely up to the discretion of whichever judge is considering the case, and in what jurisdiction and in what country. And different countries have different attitudes to different aspects of these kinds of issues. So at the minute, it's a very, very loose situation, a very loose question. Within the UK, briefly, we're seeing a lot more. We're not seeing, I don't think, a huge uptake on the right to be forgotten. I think other parts of Europe are more concerned about that than they are in the UK. We're seeing a big uptake in court actions to protect privacy. We used to have a lot of defamation cases in the UK. The defamation law was tightened up. Now, a lot of people are using the privacy law, and celebrities are using privacy law much. So this question of privacy versus freedom of expression, is something that's being worked through constantly in different court cases and in different ways in different jurisdictions. I think it becomes easier if you talk about specific cases or particular cases. So Fabio mentioned the question perhaps of a medical malpractice example where a doctor has been convicted of malpractice in the past, and what is their right to have that removed from the record. And I think it's fairly straightforward to say that it's in the public interest that should not be removed and that should not be forgotten. But I was talking to someone earlier today about another example of a woman who chose to have a very private life. She's not a public figure in any way. She chose not to have any online profile, wasn't a member of any social network, didn't post pictures online or anything. That was her personal choice and preference. But she had been the victim of a kidnapping at an earlier point in her life, of a hostage situation. And that was still out there. And as a victim of it, she objected to being solely defined by an unfortunate incident in her past for anybody who wanted to look at anything about her online, because that was the only thing that existed about her online, was the reports of that incident. And she objected to that personally because she felt that was unfair to her as the only representation of her. So you might say, well, okay, she may have the right to privacy and perhaps that should be forgotten. But the other side of that, of course, is who was the perpetrator, who had conducted it, and actually was there a public interest in making sure that that case was known about and that criminal was known about. And how do you balance her right to privacy against the public interest in knowing that somebody had committed this crime? And that's when it gets complicated and it becomes, to a degree, subjective according to how the case is argued and the attitude of a particular judge. So overall, I think this is a kind of classic case of this age-old clash between privacy and free expression. The internet and the technology companies have added a whole realm of complexity around that. The problem with the right to be forgotten, I think, is that it's interpreted differently in different jurisdictions and in different countries. And part of that is culturally different approaches to these issues, but also primarily a lack of definition and a looseness and vagueness about how this should be interpreted and the factors that should be taken into account, how it should be implemented. And I think what's unsatisfactory about the current situation is it is left too loose and too subjective according to a particular judge in a particular jurisdiction on a particular day. But at heart, Both of these are big fundamental rights, free expression versus privacy, and we have inadequate means to balance them off at the moment.
I mean, I should make clear that in the U.S. we do have a right to privacy, and there are lawsuits over infringements of the right to privacy. The recent Hulk Hogan case rested on a right to privacy, which resulted in the essential destruction of Gawker Media, $140 million verdict against them. So there are certainly certain situations where publication of private facts that would cause substantial harm and sort of shock or outrage the public or a reasonable person would be actionable. But it really has to be extreme cases. So the standard is, it really has to, again, shock the conscience of a ordinary person. It feels very loud from this angle. Anyway, so that exists, but it really is a narrow concept. And the other thing I wanted to raise is, although in 2014 this seemed very strange to American lawyers, there is sort of a groundswell in the United States to follow perhaps more European path. So there was a law proposed in the New York State legislature a month ago that was essentially a classic right to be forgotten law. And it would provide that search engines, indexers, or publishers had to remove information and other content about anyone who complains. And the terms that it used were inaccurate, irrelevant, inadequate, or excessive. So again, those are terms that are really vague from a U.S. legal standpoint. Excessive or inadequate or irrelevant. Those are judgments that we really wouldn't want courts to be making on sort of an ad hoc basis. And so there was a kind of an outcry about that in media law circles, and there was a big article in the Washington Post about it, and the law was withdrawn. But there certainly is a certain contingent, and I think it's connected to sort of other social movements that are going on in the United States, sort of the sentencing changes, a desire to reduce overly harsh sentences, and focus on rehabilitation. If you have a criminal conviction and you've served your time and you're still listed on some website as having committed this crime, you can't get jobs, things like that. I think it's of a piece with that. Sort of broader concerns about the availability of this information and the impact on the individual of this information. But at least the way the constitutional jurisprudence has worked out so far in the United States, any law like that would be clearly unconstitutional. It still seems to me a mystery that there's now more outcry in Italy and the EU against these kinds of laws.
Yeah, in fact, we were talking to someone who really went into the Italian case, knew about it thoroughly. I didn't go through the whole procedure because it's very torturous, as a lot of litigation is here in Italy. And, I asked him, was there any outcry? And he said, no, a few small sites complained about it, but the two main dailies, Repubblica and Corriere della Sera, there was really no outcry. The decision sort of slipped in virtually unnoticed, except for people who are attuned to these things. Sorry. So, should we open it to questions at this point? Questions?
Well, it was as much an observation. I don't know if you would agree with it. this drive towards privacy, in the face of horrible, intrusive journalists. I mean, one understands, it's all done in the name of, that poor individual. But the truth is, the only people who really, utilize this sort of legislation are the rich and the influential. And so therefore, I think it's a false sense of protection that we're trying to bring in to protect poor individuals, whereas in fact, it becomes a very lethal weapon in the hands of people who are able to command fleets of lawyers. Is that a fair point?
I think definitely so, for a couple of reasons. One is, yes, if someone who has a lot of resources can send out these notices to websites and then litigate it if the website doesn't do what they want them to do. And that threat of the expense of litigation in denying a request to delist is enormous. Now, Google is a giant company. They have a whole staff of people in, I believe in Ireland, who are going through these requests and processing them, right? But that's a huge investment in their resources to process these requests. A smaller search engine or an individual site, as in the Italian case, just doesn't have those resources to fight it. And in virtually every case, they're going to just pull it down because who can fight about it? So I believe you're right that it will have this distorting effect and become an additional tool of the wealthy.
Yeah, and don't forget that in the EU, in certain countries, it's the reverse of what it is in American jurisprudence. Public individuals, prominent individuals, have greater protections than private individuals. In the United States, if it's, there are different libel standards, right? And a public figure, what's the standard? It's got to be malicious.
For defamation, it's actual malice, right? So false statement of fact about a public person, in order to sue and recover damages, you have to prove that the publisher acted with actual malice, which is a legal term of art that means that they either knew it was false at the time of publication, or suspected it was false, had real doubts about it at the time of publication. So that's for public persons. For private people, the standard is lower. It's sort of a negligence standard, or a New York State gross negligence standard. Did they act reasonably as a reasonable journalist? Did they check sufficient sources? Did they seek out comment, things like that? Were they reckless? So a private person has greater protections in that case than a public official or a public person does. Again, that's the libel context, which is different, which, we're talking about publication of false information. In the privacy area, it's publication of truthful information. So the standard is even higher in that case.
Does it work? Yeah. I just wanted to ask, when it comes to class interests versus private interests, like I saw a case of a company of my area in northern Italy which asked to a specific site of a newspaper to remove an article about protests, about workers' rights. It was an old article. It was written about, 5 years ago. But they said it still affected their business in terms of, monthly budget, sales, and this kind of stuff. And they had it removed, not from Google, but from the newspaper at the end of the day. So I just wanted to know if there is any case history in the US about that. How does it work?
No, this is the interesting thing. I don't know if this is true, but somebody once explained to me the difference for the European view of privacy issues than the American, and it's because of World War II, the European experience with use of information about individuals has been much more sinister than in the U.S., right? Categorization of people, putting them on lists, things like that, has a much more sinister connotation in Europe than it does in the U.S. We just haven't had the same historical experience that you have. But on the other hand, and so this is what somebody once told me the rationale for it and the emphasis on privacy is in the EU. On the other hand, you also have a history that you want to remember, right? So I know that Volkswagen has been upset when people have published stories pointing out that they sold cars to the Nazis, right? But it's a historical fact. I mean, you can't, there are lots of businesses that did business with the Third Reich, and that shouldn't be forgotten. That can't be forgotten, right? We can't allow companies or individuals to whitewash their reputation, and it strikes me the same thing. Yes, does it harm their business? Probably, yeah. Every time somebody brings it up, people feel badly about it, and maybe it harms their business, but it's part of our history, and I don't know how we could ever decide that should be erased, or we don't need to think about that anymore. And the same thing from an American standpoint applies to individuals. Yes, do I love everything I've ever done in my life? No. Do I want everything that I've ever done in my life published? No. But people have histories, and if they were newsworthy at the time, it seems strange to me to wipe that away.
That said, a few companies have tried to sue using what they said was product disparagement, an unfair criticism of the composition of McDonald's hamburgers or Monsanto's seeds or whatever. That's been tried. The other thing that's been tried in the United States and is half succeeding in certain jurisdictions is, they're reacting to PETA, People for the Ethical Treatment of Animals, right? And PETA and other activists have been showing videos on YouTube of the horrible treatment of farm animals. And states like Iowa have been passing laws criminalizing that sort of trespassing and videotaping. It's not quite, they haven't really been successful, and PETA has a really good litigation team that has been battling these laws, but it's coming from a different way, but it's sort of the same thing as that company in northern Italy.
Yeah, and again, to be absolutely clear about this, in the U.S., journalists are subject to the laws of general applicability, right? That's the way we phrase it. They're not exempt from laws, and I think part of the concern about the reaction to First Amendment, pro-First Amendment kind of positions is that there's a sense that we're granting reporters special privileges, which is really not the case. So journalists can't trespass, just like nobody else can trespass. And again, if product disparagement is a false statement of fact, if it's actually product disparagement, if I say that you make your product effectively and you don't, you adulterate your product and you don't, that's product disparagement. That's a form of defamation, and that's certainly actionable. What I'm really concerned about is the publication of truthful statements, lawfully obtained, that somebody doesn't like, and that's really the problem for the historical record and for journalists.
Anyone else?
I was thinking that in Italy we really like to forgive and forget, also thanks to the Catholic tradition that is really eradicated in our country. And I wanted to ask if, in your opinion, the impossibility to be forgot, could affect also the moral conduct of a country.
That's a big question.
I mean, to me, once again, if you can erase your past, that you've done something terrible in your past, you've committed financial fraud, you've stiffed your contractors, you've lied to people, whatever it is that you've done, if you're a prominent businessman, and you can have that wiped away, that's a greater risk to moral conduct than somebody being able to remember it and write stories about it without the threat of litigation.
What strikes me is that in societies where there's been real division or warfare or things like that, actually reconciliation comes out through transparency. So you get truth and reconciliation committees in South Africa, in the Balkans, and so on as well. And actually reconciliation comes through opening up and publishing information rather than trying to bury it. So, I mean, I know those are very extreme circumstances, but I think an argument that says, in order to be able to forgive and move on and, get beyond these things, we better just bury this and erase them. Actually, I think there's, a lot of evidence that says reconciliation and forgiveness comes more from transparency and airing it and acknowledging it than from burying it. But that's rather a separate issue to the one we're discussing.
Stevie Wonder said, change your words into truth and then change that truth into love, right? So, I mean, that's really it. You can't move to love if you haven't, really spoken the truth, so.
I think this is the first panel I've had where Stevie Wonder is quoted as an authority, but I'll go along with that.
He's an authority on everything in my book, so.
Anyone else? Well, thanks.
Thanks for coming.
There was a man named Mario Costeja Gonzalez who was disturbed that there were a bunch of legal notices that mentioned him, and he wanted, he said that they weren't relevant anymore, and he complained to, he just wanted links to these removed. And in 2014, a decision by the Court of Justice of the EU held that Google and other search engines, if someone makes a valid request, must remove the links. There are various exceptions to that. One of them is the public's right to know, which should mean that stories, really important stories, or any story that's out there, is basically exempt from being disappeared. Now, I can identify with this a little because a few years ago on our website, we mentioned in passing a couple of Nissan executives, and someone who was a Nissan employee in the United States, but I take it she was fired, decided that my website was the proper forum for us to write an expose about all the bad things that Nissan did about her, to her, and that it was damaging his business, it wasn't really him, it was a crime that appeared there, he complained, and the Italian, an Italian agency agreed with the site, but the restaurateur was not satisfied with that, sued, and it went all the way up through from trial level to the Supreme Court, the Cassazione here, and basically they ignored the exemption, the public's right to know, and they said, after a while, and by the time it had gotten to the High Court, it was 2.5 years, and they said basically, like yogurt that's left on the shelf, there's an expiration date, the public's right to know has already been satisfied, sort of. They paid lip service to that, and the website pulled the article. That's not a great thing, obviously. We're not sure exactly what kind of precedential value it has because it's a civil system here, so it's not like a common law jurisdiction like in the UK and the US, where a high court decision has to be followed with similar cases on down the line. But still, it's worrying. It's not a good thing for Italian journalists and websites, especially smaller ones that don't have the resources to fight back. There was a criminal, she started a blog that used my name as the URL. And, you know, it went on for months. She took my profile picture from Twitter. She kept writing diatribes like, Anthony, don't you see what Nissan has done? Or Anthony, don't you see that Nissan executives are, you know, doing God only knows what. It just went on for a while. And if you Googled my name about 3 years ago, her blog was at the top. And, you know, personally, I would have loved to have been forgotten at that point. But at the same time, you know, I talked to my lawyers about it, and they said, look, she's a nuisance. Most people will see that she's nuts. It'll go away. And it took about a year, and her blog went down in my rankings. But there's an outlier. There's a case in Italy that involved a restaurateur and a restaurant in Abruzzo. And what happened was there was a crime. It's a little vague, but there was a crime happened in the restaurant. And a small site in the Abruzzo, primadanoi.it, or .it, ran a story about it. And the restaurateur he objected after a while to it being there because we had one writer who had this thing about getting a hold of copies of emails and constructing long narratives of company officials, especially lawyers who did really bad things. And Fabio very patiently read them line by line and wasn't too bad about telling me to soften stuff or take things out. And now he has probably the best legal job in New York. He's the general counsel of the New Yorker magazine, and he gets to read everything and be in what is still, for journalism these days, a pretty rarefied atmosphere. And to Fabio's left is Richard Sambrook. He's a J-School professor at the Center for Journalism at Cardiff University. He was for 30 years, yeah, we're around the same age, for 30 years at the BBC. And so what we're going to talk about is, I went a little over the top and said the right to disappear, it's really the right to be forgotten, but I thought I would hype it a little. I'll start with some scary stuff, and these two guys are going to try to walk us off the ledge a bit. Right?
See how we go.
So this all started in 2014. Well, welcome everyone. Good to see you here and not out there. Although if we finish quickly, go out there. It's really nice. I'm Anthony Paunita. Until January, I was the editor of Corporate Counsel magazine and on the staff of The American Lawyer. Before that, I was an editor at the National Law Journal. Legal journalism is well established in the United States, quite a bit less well established here, and I mean, Britain, it's done pretty well. There's Legal Week that is now a pretty decent website. In Italy, there's actually a constellation of legal sites around one company. It's all legalcommunity.it, and they're trying to do a pretty decent job. A lot of it is gossip, you know, this person came here, but, you know, they're trying to develop a following, and they also have corporate legal branch, and they're branching into the food business as well, the economics of the food business in Italy, which I think is pretty interesting, and it's a big compartment of what this country does. Next to me is Fabio Bertoni. Years ago, he was my in-house counsel. He very patiently vetted stories that we ran, especially